Good morning, afternoon, evening, whatever. By the way, if you look at my shirt, it does say, "I'm afraid not." If you see it, I hope you think that's funny. Um, Hope everybody is well. Good morning, good afternoon, wherever you are. I guess it's good evening for Lee out there. It's good evening. Could be in the middle of the night for somebody. Kind of tried to decide that did this one today without much fanfare. Just kind of wanted to throw this out, and eventually I figure people will see it at some point in time. I wanted to address obviously a bunch of stuff, but I'm going to focus on three things, a little different, uh, different group of topics. I'm going to talk about earthquakes. I'm going to talk about the debate, and I'm going to talk about GTII and anything else that comes up that you guys might have as a question. If I could see your question when I looked that way. Um, of course, this is just my opinion. It's not legal advice, obviously, as the name suggests. It's do your own work. Don't rely upon anything I say, of course. Hopefully, it will stimulate you and you'll go out and do your own thing and figure it out. Before I start, of course, talking about the debate, I think I put in the order I said earthquakes, debate, but I think I'm going to go debate, earthquakes, then GTII in that order. So before I start that, of course, and this is a joke, by the way, so I have to say this before I start, but then you'll see exactly what it means. I'm one of very few people who has to provide instructions before a joke, literally, as I just did. So I just proved my point. Um, uh, for those of you who are football fans, the 49er kicker, his name is Jacob Moody, is often depressed, but sometimes happy. Where do the best comedians in Qatar? First of all, we have to have a discussion about Qatar. So some people call it Qatar, some people call it Qatar. I don't know how you could have two separate names, but there appears to be. So now let me go back. Where do the best comedians in Qatar come from? Of course, they come from Doha. And last but not least, a lot of people, at least 5, accuse me of having random, disconnected attempts at humor. And potatoes are certainly my favorite fruit. All right. Thank you, everybody out there who tolerated all those. Those were all originals, by the way. They're not always all originals, and I'm sure it's amazing what's going on. I have before I go forward, I don't know if you could see it. You probably can. I have a spot on my nose because I went to the dermatologist. I think it's a good idea as you get older, and especially if you're in an area that gets a lot of sun, to get regularly checked. So what they do is if they find some spot that they have an issue with and it's not a significant issue, they can just freeze it. They kind of spray the stuff on you and then it forms like a little scab on top. So that's what you see. And hopefully, or perhaps you may experience that in the future. But certainly if you live in a state and you have out in the sun, wear sunscreen. You have to change it every 2 hours. Boy, I'm giving you a public service announcement too. Every 2 hours, change your sunscreen, get checked, cover your skin, etc. When I was a kid, this is just funny. When I was a kid, so as a teenager, we used to go to the beach out in Southern California near Marina Del Rey. That was a place we used to go to. And I have pretty dark skin, so I don't require a lot of sun to get pretty dark. And I had a friend who had light skin, and he used to and this was acceptable. So this would be the 70s. This would be acceptable to just lather yourself with oil and then put yourself in a frying pan and let the sun cook you. And I remember with him and another gentleman at that time, we were on the Gong Show. This was some stupid show, a talent show way back that was going on in the 70s. And we were on, and they give you prizes if you do okay. And we got some prizes, and I remember the prize that he got was this super rich suntan lotion. Again, not sunscreen, suntan lotion. It would cook you and fry you. Just funny how things change. That was the 70s, and today, not a chance. Anyway, so I've given you the skin cancer dermatology. That's that part. Now let's talk about the debate. So debate, I saw the debate. I have no person I'm favoring in this election because I'm not voting for either. So I'm no fan of either. That's my position. I've stated it before. I'm not a fan of either party. I support anybody who wants to vote for whoever they want to vote, then go for it. But I'm no fan. So when I was watching this debate, and I usually don't watch this stuff, I was more of interest. And I was thinking about how it compared to the Biden-Trump debate. The Biden-Trump debate, the burden was on Biden to perform. He was abysmal, and that literally threw him out of office. Now, what he's doing now, of course, I don't know, because theoretically, it appears to me we don't really have a functioning president, and there's some committee. I don't understand why this is not a big deal, whether you're a Democrat or Republican, who's running the show. But that's kind of a side issue. But the first debate, really, the burden was on Biden to perform. He did not. I thought Trump's performance, and again, at that point in time, I was voting for neither of those guys either. I thought Trump's performance was Trump below average, not very good, but Biden was a disaster. So coming into this debate, I thought the burden was on Harris to show that she wasn't a complete flake. That's kind of where it started. And I thought if I was going to score this one, I scored this debate 60-40 for Harris. So she met her burden. Now, how that translates, however, I don't know, because people make a big deal out of it. But now we're just even a few days after the debate, and it's the discussion has already kind of trailed off a little bit. We're late in the election, this unusual election cycle. So I really don't know what, if any, impact that debate will have, notwithstanding how it went. And obviously or not obviously, but apparently there's not going to be a final debate. I think that's a wise choice for Trump, unless he really prepares. I didn't think he was very prepared for this debate. I thought Harris was. I thought the moderators were one-sided, pro. I don't know if they were pro. I don't know if they were intentionally trying to be one-sided or they just were one-sided. I don't know which one. I don't like to attribute motive if I don't know. But they certainly were one-sided. However, there were so many opportunities, I thought, for Trump to go after Harris where she would give an answer and he went elsewhere. So that was my view of the debate. I think in the end it may not be meaningful. How's that? It would have been meaningful if she was complete skunk. If she was like Biden in the first debate, then that would have been it. I think that would have been, the election would have been over. So if you look at the current polls, and I look at them, it's pretty close. She got a little bump, and then it kind of came back, and we'll see how it goes forward. I don't think the vice presidential debate really has any impact on the election. It may be good for the people performing, but otherwise I don't see it. So I'm not concerned about that. But that was my take on the debate. Thought she won. I didn't think she was great. I thought he was poor and unprepared. He must not have taken it too seriously. And again, maybe he thought it won't have that much impact in the grand scheme of things. Or maybe he underplayed her. I don't know. But that's the way I see that. Okay, let's debate. So earthquake. So yesterday there was an earthquake in Southern California, 4.7. Now what's interesting is I was within 5 miles of the epicenter. So where it occurred, I was within 5 miles. 4.7 is moderate, light, heavy, light to light, moderate. So generally, I think they say it has to be at least a 5.0, and depth makes a difference also. It has to be at least a 5.0 where it starts to cause some structural damage. But anything under that, then probably not. And of course, it depends on the depth of the earthquake. The deeper the earthquake, the less impact. This one was at, I think, 7 miles. That's generally considered to be shallow. and most earthquakes in Southern California tend to be shallow. So, at least in my experience, they tend to be shallower. Some places they're really deep, and obviously that's less of an impact. If they're offshore, there's a different impact because the earthquake produces certain kind of energy waves, and if it's in water, some of those waves don't travel through water. So if it happens offshore, you might get a different impact. But then, of course, if it's big enough, you also might get a tsunami, or if there's a big enough landslide. Where did I see this? There was apparently a landslide in Greenland last year, I think, or this year, and locally in the area of the slide. So it was literally land falling, I think, into the water, and at the location of where the land hit the water, it created a wave 650 feet tall. It spread out, so it covered quite a big area. So it was, miles of area at like 50 feet, a 50-foot wave, but way out in the middle of nowhere. So it didn't really impact anybody. But that was just a fall. So this earthquake that happened yesterday, 4.7, that related to apparently an earthquake fault that is just a couple hundred meters long. So it's not a big piece of land that is slipping. And usually it's slipping. One is, I think it was a strike slip, which means like something goes like this and something's going this, and it kind of like, it causes a upward movement. But it was like tiny little area that was impacted. So you can imagine, and that's what controls the size of an earthquake, is the size of the fault. So just was interesting that this fault was very tiny and still caused quite a jolt. So I was sitting 5 miles from the epicenter in my car, and I had done this about a year ago, same thing, and my car definitely jumped. So it was like you couldn't have mistaked it. First, you get a little bit of a roll, and then you start to wonder, what is that? And that's a lot of, by the way, that's a lot of earthquakes that we experience. You wonder if you just felt an earthquake. That's what you think, because they're generally very small. But here, I felt a rolling, and you could definitely feel a rolling. And sometimes you can actually see the ground change shape and configuration. It's really interesting, just to say. And then my car jumped. So my car was bouncing, I would say, for 5 seconds, probably, like real bounce. And at that point in time, there's nothing happening other than that's kind of, you're watching your car bounce. But you, being a veteran of earthquakes, you wonder, you don't know how large the earthquake will be. Almost all of them stop, and that's it. But, every once in a while, they continue to grow. So you don't know. So while it's shaking, you're not really concerned about the shaking. You're concerned about where it's going. After about 5 seconds, that kind of up and down shaking stopped, but I could feel rolling, literally rolling, and that probably lasted 10 to 15 seconds after that, and then it stopped. And I'd say about 10 minutes later, there was an aftershock. Aftershocks, obviously, are earthquakes that happen after the initial earthquake, and they are, an aftershock by definition would be smaller than the earthquake itself. And generally, if an earthquake, like we had a 4.7, generally an earthquake will be, the biggest aftershock will be 1 point less than the earthquake. So if it was a 4.7, then probably the largest aftershock you should get is in the range of 3.7. And the difference between 3.7, well, let's use even numbers. The difference between like a 4.0 and a 5.0 is not 1. Even though that is 1, 4 to 5, in terms of the energy that's released, the way it's calculated, the difference is 10. So a 5 is producing 10 times the amount of energy as a 4, and a 6 would produce 100 times the energy of a 4, etc. So you could see when the numbers grow that the amount of energy that's being released is substantially larger. Now, I live in earthquake country. We have them not as regularly as other places like in Japan where they have them, it seems like a lot more. And you kind of get used to them. And like any place you live, you forget about it. You don't focus on every day. I'm sure like if you're in Louisiana, you don't focus on hurricanes every day. When it comes, you deal with it, and otherwise you kind of let it go. And that's kind of how people's brains deals with that. In my lifetime, I've lived in Southern California almost all my life. Two earthquakes that stood out that were really memorable to this day. 1971 Sylmar earthquake, which is in the San Fernando Valley. It was measured somewhere 6.5, 6.6. And I was a kid, 71. I was 94 years old. What I remember about that one is after it continued to shake, not that it was shaking big, not that these were big shakes, but my recollection is for like 48 hours, every like minute or two, there was a little aftershock. And you get like a little PTSD from the initial shake, the initial earthquake. So any aftershock that comes afterwards, you kind of wonder, is this going to be another big earthquake? So it was very unsettling, to say the least. And the other one I remember that stood out was the Northridge earthquake, was in 1994, and that was measured at a 6.7. And what I remembered about that was during it, going to check on my little kids, and we have a 2-story house, and upstairs it looked like the floor had turned. So it almost looked like if you go look at like the old Batman series. I don't know if any of you have ever seen the old Batman series. It was a TV series, but when they would show the criminals, the room was always distorted. It wasn't straight, and that's how the stairs looked. So literally, the energy that was being produced was changing the shape of the building. At least that's how it appears. And I know if people are outside and they look, they can actually see they can see like movement on the ground itself. It's really interesting. But again, we live with it. I've lived here, basically all my life. I've experienced, never experienced like the great earthquake. They talk about in California, they talk about the great earthquake. They've talked about it my entire life. It may happen today, theoretically. It may happen while we're doing this live stream today, but it might not happen for another 500 years. And their ability to give you a precise calculation doesn't exist. They give you odds. They might say, and this is kind of what they do, they might say, in the next 30 years, there's a 50% chance of a earthquake of this size. That's how they kind of do it. But anyway. Earthquakes are interesting. There's a 5% chance in any earthquake in Southern California that the initial earthquake is a foreshock. So I told you that aftershocks are always less than the initial earthquake. The foreshock is the reason why it's called a foreshock and not an aftershock is that first earthquake that you thought was the real earthquake was just the appetizer, and the real meal is the foreshock that's coming on. So that's my spiel about earthquakes. And if we have, again, like I said, if we have an earthquake while we're doing a live stream, I was hoping maybe we at least have a aftershock or something, and we could experience it together, but I don't know. And if you look behind me and you can't see anything, actually you can see there's a mountain. So that's literally, that's not the correct mountain, but there is a mountain in the background, and it's about the distance from where I am to the mountain behind me, a couple of miles, and it's about 2 miles behind that mountain that literally the epicenter where the earthquake was. So literally it was right on top of us, which is really also interesting as we go, at least interesting for me. All right. Now, last but not least, of course, let's get to GTII. So I know not many of you may not be interested in GTII or have any interest in GTII. But anyway, I'm going to talk about GTII anyway, notwithstanding the fact you have no interest in GTII. So GTII, if you recall, I think last time I spoke about the order. So there was a minute order. The minute order is the order of the judge telling you, this is how I think about it. And then the judge communicates that to the attorney that won and says, prepare a bigger order that spells this out in legal terms. That was done. That was provided to the other side as required. It was submitted to the court. No alternative judgment was submitted as far as I know. So at this point in time, based upon a very current and recent discussion, we're just waiting for the judge to sign the order approving everything, plus appointing the receiver and letting him get going. Separate and apart from that, and I don't know if it will impact the timing of the signing of our order. I asked the question. I was told does not, but I don't know. But theoretically, anything can happen. But sometime after our last, whenever we did the last live stream that we talked about GTII, whenever that was, and today, the GTII folk filed a motion for reconsideration of the motion granting the receiver. Now, it was, I can't get into, I will, and we will talk about it. I have to give this a code word. So I'm going to say the code word for this is monkey order. So so all you out there, down the road, I'm going to talk about monkey order, and then it'll make sense. But I don't want to talk about monkey order at this point in time. But if you recall, there's a minute order, and then the final order. They didn't submit a contrary order. They filed a motion for reconsideration. Motion for reconsideration deals with one out of the 4 reasons for the appointment of the receiver, and I believe that the grounds stated for various reasons are incorrect. But what I was thinking, the way they did it, and I'll get into a little more detail, but the way they did it would be like if you were accused of stealing a microphone, a bottle of water, a telephone, and a computer. That's what you were charged with. And your defense was, I didn't steal the bottle of water. That's kind of the way I see their motion for reconsideration. Motion for reconsideration is a motion you can file after an order of the court based upon new facts. So what happened since the day of the motion that requires the court now to intercede? And you have to have not been the facts, it's not that she didn't have the facts, but the facts couldn't have been available to you when you made the motion. So we had the motion, there were a bunch of pleadings, etc. They filed the motion for reconsideration. They kind of renewed the same argument that they had made and they didn't address the others, but they renewed kind of the same argument they made at the hearing about the 10%. But they didn't talk about the other 3 statutes that provided the court the means for it. And that 10% issue, I think, has been handled anyway. I think it was properly dealt with in the papers and in the hearing, and it's been handled, as far as I can tell, it's been handled since. So that basis, I just thought, again, didn't make sense to me. Again, the guy who's accused of stealing the microphone, stealing a computer, stealing a telephone, and stealing a bottle of water, if your defense is you didn't steal the bottle of water, that's probably meaningless in the grand scheme of things. And that's kind of what they did. Their second basis, so they claim it's basically jurisdiction. They say they shouldn't go ahead and you don't have power, etc. They didn't really dispel the jurisdiction on the other basis, those 3 other statutes that the court said we could grant the receiver and TRO on these bases. But the other basis, I think, by the way, there was just a little aftershock, maybe. The other basis that they raised was that Rabari should not be, he shouldn't be included in the order, and he shouldn't be excluded from being the receiver. which I find interesting. And he filed a declaration. In this declaration, which I found really interesting, and I was babbling on about that. At some point, it was referenced that Rabari would take over May 1. And then I started babbling about in the employment agreement dated July 2nd, it said April 1 as opposed to May 1. And if you all recall, in April of 2024, that's after April, we get eventually we get the financial state, the 10K, we get Borgers out, we get the downlisting number 2, etc. We get a whole series of events, but April itself was pretty meaningful because that's the day of the 10K. And so I was babbling about, here it says May 1, and it says May 1. Here it says May 1, and then in the employment agreement, it says April 1. That's a July 2nd. You could find it. That's fine. And so I thought, I was wondering if that was intentional. Maybe perhaps it was a way of, and I'm just speculating, pure speculation here. I have no facts, nothing to support this. But my thought would be perhaps Rabari was trying to protect Reichman, and instead of May 1, he would take over April 1, that meaningful period of time. And because there's an indemnity agreement, and what again, an indemnity agreement is it says that we, GTII, will cover any claims, legal fees, etc., brought against you, Mr. Rabari, for any claims brought in your role and capacity for GTII. And in that July 2nd employment agreement, that's part of it, an indemnity agreement. So with that in place, I wonder then if someone would be willing to backdate the start date to protect someone else. That's my only thing that makes sense to me. I mean, again, I don't know. So it's pure speculation, why they backdated from May 1 to April 1. But in the declaration that Rabari just filed in the motion for reconsideration, which I'm just talking about now, he indicated the April date. So he's confirmed the April date. So even though they stated like a lot of things, even though he stated May is the date, they backdated to April. So seems kind of funky to me, but that's what it says. The other thing that was interesting, and again, in the hearing in Nevada that occurred in front of the judge, I think I indicated that the attorney for GTII, the bad guys, of course, they indicated the reason why those shares. So in January 25th of 2023, something on the order of like 66 million shares are issued, about 36 million plus to who, to our guys, directors, officers, those kind of people. And during the hearing, and eventually those are canceled, like 18 months later, about half of those shares, 36 million, are canceled. We don't know what other happened to the rest. And I think there was reference before, pretty sure there was reference before, not going to swear to it, that the reason they were getting paid was for past consideration, past work, etc. So during the hearing in Nevada, the attorney for GTII indicated, volunteered, by the way, that they were being paid for a future deal that didn't close. So they prepaid themselves on a future deal. And I don't remember if you all recall, the judge was not very pleased by that. So there's a whole line of circumstances that would relate to that, and why they didn't find out about that earlier, and why no action's been taken about that, and why the 10K was bad, and why Borgers was there, and why they haven't corrected the original downlisting, why they haven't corrected the second downlisting, why they didn't issue an 8K for the second down listing, why the investors relations website is still false. And all these things, all these events occurred after April 1. So interesting to me. So their point was, and no legal action taken, as far as I know, no legal action taken by either Mr. Rabari or GTII against former management for the misconduct that even Mr. Rabari indicated, because he indicated he agreed with the decision of the board to cancel those shares that I guess were erroneously or inadvertently issued for the deal that didn't close in the future. But they took no action about that, didn't explain the 30 million, never explained, by the way. So I've never got any explanation. Just another idea. And again, these are all reasons why, in my opinion, Mr. Rabari should not be the receiver. But if you recall in the, or maybe you don't recall, maybe I don't recall, maybe we all don't recall, there's a press release that's put out April 9th reflecting, I think it's an April 7th, 2024 board meeting which they engaged the services or agreed to engage the services of Mr. Rabari, which makes that April 1 date kind of interesting. It's kind of on the side. And in that, when they describe, they say that they hired him to do a succession plan. I think they reference that. I know they reference that in July and they represent in December 2023. So they say they hired him to do a succession plan. He never completed the succession plan, as far as I know, because in July of 2024, Reichman says in a PR, if I recall, he says he's there to complete a succession plan. At least that's what it seems to say to me, in my humble opinion. What I read, I could have been mistaken, but that's what it seemed to suggest. But the point, that the kind of the more relevant point, and again, not disclosed, and no detail, no 8K, no nothing, but it says in the PR, April 9th, it says Rabari discovered, and these aren't the exact words, by the way, so it's kind of my summary, but it says Rabari discovered structural and operational deficiencies in the company. And this is the company talking about it. So the company's talking about Rabari. So Rabari found these deficiencies in the structure of GTII and the operations. And to correct those deficiencies, I found this, by the way, humorous. To correct those deficiencies, they didn't correct the deficiencies, they hired Rabari. That's what it says. That's how they dealt with the deficiencies. They didn't correct them, they hired him. Found that kind of interesting. But nobody's ever disclosed what those deficiencies are. And if they were significant enough that they justified the hiring of Rabari, then shouldn't they have been disclosed? That's my view. Somebody asked a question: did the judge sign the order? No, the judge did not sign the order. It's with him. The other side did not submit a contrary order. So our guys think that the judge will sign off on the order, and we'll go from there. Judge got the order, I think, Monday of this week, so has had it 5 days. This judge is busy. I mean, as we know, because it took a couple weeks to get the original minute order. This judge is busy, but we would expect an order to be signed, any day now. The only caveat, I was kind of talking about that indirectly, but the only caveat is there's a motion for reconsideration, but it's probably a bad motion, and I don't think the judge will wait. And I asked that to counsel. They didn't think he's going to wait either, but anything's possible. And the motion for reconsideration is not heard to the end of October. But I don't think the judge will wait. And again, nor did the attorneys for us think that, but you never know. So the order's sitting on the judge's desk and has for about 5 days. I would expect, hopefully he prepared the minute order. It took him about 2.5 weeks. So we're about a week in. So I'm guessing it probably that same kind of period of time. Unless there's some, and I'm answering that question still, unless there's some stay that's issued, and I haven't seen, there's no request for a stay, nor would this, I don't think, I'm not speaking for the judge, nor would I expect the judge to issue a stay currently, but you never know. But I don't expect it. I don't expect it at this point in time. But now going back to the two prongs, so their motion for reconsideration, so that's pending the end of October. So one was the 10% issue. I think it's been dealt with because I did have communications. I think it's been dealt with. And even if it wasn't, there's multiple other bases. So I really don't understand the reason. And the issue about Rabari being the receiver, I don't think it makes any sense beyond what I just said, like happened since April 1 on his watch, because as of April 1, he was the chief operating officer. As of August 1, he's the chief executive officer. As far as I know, nothing's been corrected. I do note, I believe that an audit is in process. I don't know if it's going to be complete. And I don't know if the receiver, once he's appointed, will accept that, whatever completed audit. I'm sure they will evaluate it. I know they have their own auditors. I know they have their own counsel. So we will find out. So again, to summarize where we're on with GTII, an order has been submitted to the court. So we had originally the minute order, then we had the formalized legal order. That formalized legal order is with the court. Once they sign it, unless there's a stay, the order is effective. Effective immediately, which means the receiver would then take over operations. I was told that the receiver is in the process of preparing a plan to recapture assets of GTII stock, whatever, could be other things. That's already in process. And again, the receiver acts at under the direct supervision of the court and me and all you guys, all the shareholders. Nothing will get done that we're not aware of. Nothing material, really super material, in my opinion, gets done without court approval. So kind of that's it. So the last part, and motion for reconsideration end of October. Will that change anything? I don't believe it will. And again, monkey order, remember that's the code word, because I don't want to talk about that yet, but that does relate to the motion for reconsideration. But for various reasons, I don't think it's a well-taken motion, and I think they're going to lose. And I'm assuming and expecting that the order appointing the receiver and giving them powers to start correcting the deficiencies, etc., will be issued within the next week, is the way I'm hoping and expecting. Could be longer, but that's what I'm hoping and expecting. If that changes, and if we get 2 weeks down the road, the longer it takes beyond like another week and a half. So if we get a month, we're a month in, and it still hasn't been issued, then I'm wondering if the judge is waiting to rule on the motion reconsideration, and that just might be denying the motion, but it would be it might be the case of such. I'm pretty confident about that motion being denied. I just don't know when and when order. And I'm hoping the judge, who was very strong in his minute order, is just as strong in terms of how he rules on the actual order. And the actual order delineated all the misconduct that we talked about originally, like there's 10 items, and again, these are off the top of my head, but it's like non-disclosure, false disclosure, conversion of company assets, giving shares to family, all that kind of stuff. There's a whole litany of things. So that's all in. And then so the order is about 20 pages long. Let's say 6 pages of that, and then the rest, another 14 pages of specific items related to what the receiver can and cannot do. And again, interesting enough, there was no contrary, as far as I know, there was no opposing order submitted. They could have done that. I don't know why. I do know that the attorney in New York, who I had contact with, who's also a shareholder, is not currently representing GTII. I think I mentioned about a week ago, I had contact with him, and it appeared he was going to come in, and perhaps he will at some future point. But as of now, he's not. He's also a shareholder, so he's in an interesting position. I've had communication with him. So I'm trying to think anything else. So next part is, I would expect, perhaps maybe this coming week we'll have the order, and then I'm going to get in contact once the order is signed. I will obviously get in contact with the receiver to find out what his plans are, timing, what his expectations are. And he may not be able to give me precise plans. I don't know if he could come on to the to live stream and do it. I don't know if he would do that, but I'm going to ask. I'll see if he would do that. Wouldn't do it until he was appointed, obviously. But that's it. So anyway, there's a long list of things he can and cannot do. Once he accomplishes the main goals, then he will cease being the receiver. And again, one of his powers is to get rid of management. So he can hire and fire, change the board, etc. With approval of the court, of course. And I'm sure there will be opposition. Why will there be opposition? My guess is there will be opposition because, and again, I'm pure speculation, but somebody like Luke Rabari. So he's the COO, CEO. He's gotten 8 million shares. He has an employment agreement that gives him the right to get over a couple of years, I think it's over a couple of years total, to get approximately 24 million shares plus an additional 10 million shares if the price of the stock goes to $2 or more. So it might be the case that just if that's 34 million shares at $2 is nearly 70 million bucks. It could be worth more. So if that were me, I would expect that somebody in that position might contest some of this based upon their personal interest. By the way, which, just between you and I, someone having that big a personal interest in the outcome about who do they go after and, their shares, does that, I'm just thinking out loud, by the way, does that create a conflict of interest between the current COO and shareholders of GTII? Would they be better off if the shares were not issued to Mr. Rabari? Would that dilute the interests of shareholders? Would they prefer if he went out after existing or prior management? Would they prefer if he stepped down? Would they prefer if he or GTII stopped spending money on legal fees related to these proceedings that diminish the financial capacity of GTII? I don't know. All those are questions. I don't have any answers for, but it surely, along with that, indemnity agreement, what I mentioned, the indemnity agreement again is an agreement that protects someone from liability claims and attorney's fees if they are sued in a certain capacity. And at GTII, per the filing, the 10K filing, it was an 8K filing, that was July 2nd of 2024, I believe. There's an indemnity agreement. And it's from GTII. I think it's signed by Mr. Reichman for the benefit of Mr. Rabari. And I don't know when the period starts. I think I looked at the agreement. I don't remember it being clear as to what period it starts. So, for example, could someone who got an indemnity agreement cover prior claims? I guess they could. I don't see how it's in the best interest of shareholders, but I guess you could, theoretically, if it's negotiated in good faith for the benefit of the company. I don't know. But if you have an indemnity agreement with a company that has very, very little money, then who is going to pay the legal fees and potential liability? Some might say it might be another member of the board of directors or former officers. For example, let's say there is a former officer or former executive officer who has a lot of money and runs the company or backs the company. Then aren't they, and again, it's pure speculation on my part, but if there's an indemnity agreement, aren't they the indemnitor? In other words, aren't they the ones who are protecting the other person? Because if the company has no money and there needs to be legal fees, and if everybody wants to make sure that everybody stays in line, doesn't that require somebody to pay the legal fees of the other? And if they are, doesn't that make it difficult for the person who's getting legal fees paid for by someone else to then go against that person. So just purely, speculation. I don't know anything about this, just guessing, don't rely upon this, etc. But if in fact Mr. Rabari thought that Mr. Reichman, in essence, was bankrolling GTII and was indemnifying really GTII, so if there was a showdown, he would be the one fronting the legal fees, wouldn't it make it, and then it's just a question, wouldn't it make it hard then for Mr. Rabari to then go after Mr. Reichman on behalf of GTII shareholders? It would seem to be there was somewhat of a conflict there, and there might be other such conflicts that exist in their relationship concerning conduct that has occurred, and I don't know this for a fact, but I'm just speculating, that creates such a conflict. And if there's such a conflict, how possibly, in what world, could then Mr. Rabari act as a receiver and watch out for the interests of the shareholders? That's really difficult for a human being to separate out those emotions and be able to do a professional job. I don't think it's prudent for someone in that position to act as a receiver if they have either an actual or perceived conflict. And if nothing else, there's a perceived conflict, right? Even if there's nothing between Mr. Reichman and Mr. Rabari in terms of who's protecting whom, etc. Even if there's nothing between them, it looks like there could be. And that apparent conflict is enough to disqualify somebody from being a receiver. So that's the second part of the motion for reconsideration. So the first part, again, was that 10%. And again, went over, there's 3 other bases for it other than that. And since the motion was made, that issue, in my mind, has been dealt with. And the second part is should Rabari be the receiver? So I think they lose both. I don't think the court will let, and it doesn't really make any sense to me. Even if he's, again, wonderful, he's the greatest human being. If he's wonderful, he would be a wonderful receiver. If he's a wonderful manager, it just doesn't make sense, and wouldn't make sense to have him in that position, notwithstanding everybody's great intentions. Because we'd wonder, all of us shareholders, wouldn't we wonder, is he really operating in our best interests, or is he operating in his best interests or somebody else's best interest? So next week, hopefully we find out about the receivership, and then we'll have more dealings, I think, involving the motion that I mentioned, motion reconsideration. My stuff has already been filed. I will, in other words, the case that they filed against me for defamation, where they claim that everything that I asserted, and I don't even know if I asserted it, but everything that I asserted about bad management, that I was untruthful, I'll leave it at that. But that's ongoing. There's multiple motions for sanctions pending. I've asked to be dismissed multiple times. I think it's a purely frivolous lawsuit brought in bad faith. I really don't understand what their thinking was. Originally, they did it to shut me up, I'm sure. And it maybe had a positive impact. But once that judge in Nevada came down in favor of shareholders, seems like their action is really nonsensical. And if you recall, they also came to my house at 6:30 a.m. on a Sunday morning to serve a copy of a letter that they already had emailed to me at an address that wasn't referenced on the letter, which pissed me off, by the way. And that's referenced also, because in those motions, one of the bases for granting one of those motions is you can't bring an action for an improper purpose like harassment. And I thought that was clear evidence. I don't think you make a good faith argument that that's not harassment. I really do. How do you serve somebody with a letter you sent to them That's not like a complaint. It's not like legal process. At their home at 6:30 a.m. on a Sunday at an address not listed on the letter. Suggests to me they're trying to make a point. And they did. But I don't necessarily think it is turning their way on that point. But anyway, so that's ongoing. I've asked to be dismissed. I've asked multiple people to be dismissed. If it doesn't happen, we'll have to let a court decide. If that doesn't happen, I've already indicated if that does not happen, if there's an action still pending, then of course, I'm filing a lawsuit against both Rabari and Reichman for breach of fiduciary duty and whatever else applies. I dismissed my original action, but without prejudice, because I was going to move into the Nevada action. I didn't want to create, an inconsistent position. That's right, from The Godfather. All right, that's a great scene in The Godfather where I don't remember if it was like a movie producer. They were asking for like a movie producer to hire somebody to use them in a movie. He refused, and then he wakes up with a horse's head, and he had a prized horse. Might have had prized horses, and then he wakes up with a horse's head in his bed. That was very powerful, and I think it worked. I think as a matter of fact, that gentleman they were pushing to get the role, he got the role. So it was very influential. I'm not accusing them of doing that, but I think they were trying to make a point and try to shut up any dissent. And I think the fact that the minute order from the judge in Nevada was so harsh against them, justifiably, I think it kind of puts them in a difficult position. So I have no idea what their strategy is this point in time. It makes no sense, honestly, to this point in time. In light of all those facts, even if I was wrong, it makes no sense why they're still pursuing me, because I get to talk about this stuff. So I don't understand why. It seems kind of odd and silly, but sometimes we don't know. October 9th. I don't know what October 9th is, by the way. But October 9th is a good date. Today is September 13th. So in case you were asking me if it was today was October 9th, no, it's not. Today is September 13th. I'm trying to look to it looks like I'm looking to my left, but I'm actually looking to my right if I see any other questions. So I'll put this one up here. Do we know? We don't know, because there's all just so the question is, do we know if Reichman was giving money shares away to family members as a side project? We don't know, because we know allegations. There are allegations in the Nevada complaint of that, and the court in the minute order seemed to find that. I don't know what the side project reference is, but it seemed like at least the judge in Nevada seemed to find that his family members were personally benefited, other insiders, if you recall, foundation. And about the foundation, that's an interesting, thank you for actually bringing that up. So apparently, and it was, I think, the Anson Fund that was brought up, is sometimes what happens is at a time the price of stock might be inflated, especially penny stocks. An investor might donate that stock to a foundation. If they do, they can get an investment tax credit that they can carry over that will offset, obviously, income at some point in time. And at some point in time, they have to reconcile this at some point in time, but they're able to do that. So someone suggested that, and I don't know if it applies, by the way, here, because I really don't know. I don't know anything about the foundations or what happened other than the allegations I saw in the complaint in Nevada. But I don't know if that was the case in this case. At this point, I don't know if the valuations of the stock, because there's valuations. I don't know if it's based upon the market price. It's based upon what some CPA says. If it's obviously dependent upon when it's taken. But somebody might establish a foundation, donate, for example, you might donate GTII stock at a high point, might get some kind of tax credit, and be able to use that tax credit using a price that may not, on the stock, that may not accurately reflect the price, or at least that was what happened in Anson. And I don't know if that happened here, but it was interesting because we know there's foundations involved, and concerns about foundations is expressed in that complaint in Nevada. And it would have been expressed in my complaint in here too. Are they working with Kramer? I don't know. And I haven't seen anything, by the way, it's an interesting question about Kramer. I looked recently about Kramer, haven't seen anything new updates about that in particular in terms of meaningful updates. I don't know if there's discussions. I don't know if, like, for example, the Kramers are speaking. I don't know about that. Recently looked at Alpine, have not seen a decision on Alpine in terms of their appeal in DC and the status of that. I did see, by the way, I went to some seminar and they talked about the Supreme Court's ruling in Jarkessi, which is the case where the SEC was trying to collect some kind of sanction against a broker. I don't remember where the broker was, maybe in Pennsylvania, something like that. It was something like $300,000 sanction because the broker was deemed to be a scumbag. That wasn't the technical term, but that's what they, in essence, was. And the SEC handled it within their own judicial system. They have 3 administrative law judges, some investigators, but they do it like FINRA does. They investigate, prosecute, and in essence, judge. And the Jarkessi, and the case went up to the Supreme Court and was decided recently. In that case, they said that the SEC shouldn't have the power to conduct can't be judge, jury, prosecutor. They shouldn't have the right to do it. And it's based upon the fact that when money damages are sought that are not purely statutory from a federal ground. So, for example, if it's money damages arising out of fraud has been around for a long time. It's back in the, even in the dark ages, they had fraud, but it's common law. So it doesn't require statute, just the way it's been. So somebody cheats somebody, that's fraud. And so if a claim like fraud and related claims that exist and money is owed from that, then when the government comes after you, and the SEC is considered the government, you have a 7th Amendment right to a jury trial. And the SEC can't adjudicate that in their system. So you have a right to go in the federal court. And so that was just what happened. And a lot of people believe that we'll see a lot of changes in terms of how agencies operate, their power structures, the decision making. For example, for retail shareholders, FINRA has been no pleasant assistant. And for anybody who's in the MMTLP crowd, we know that they're bad news. They're immune, etc. But perhaps if they can't, and they have their own system also, so they also adjudicate, investigate, and then they have a private arbitration system. They have their internal adjudication system also. And it's not really fair for retail shareholders. Obviously, I have participated in a FINRA arbitration and illustrated it in process, just so everybody would have an idea of what was going on. And it's certainly not fair. The participants in those arbitrations are generally, they appear more than once, and they contribute income more than once, and they support FINRA. So it's just an unfair system. So with the Supreme Court ruling in Jarkessi, the point is that perhaps agencies will lose power. Perhaps we will get a better shake as retail shareholders. Perhaps the shorting will come into less of an issue. Perhaps we'll just have stock settlement, because that's an issue here throughout is stock settlement. But anyway, the Jarkessi case is maybe the start of that. The current Supreme Court looks to seem to limit the power of federal agencies, and not that federal courts are all necessarily great, but the point is the difference between having a hearing and an adjudication in a SEC place or an arbitration versus a court is this. One, it should be neutral. 2, it's a real judge. 3, you can get a jury. And 4, you can get much larger damages. So if you're then the financial institution, and if you're evaluating a matter, if you're, let's say, in arbitration, you've had experience in the arbitration system, the case has a certain value to you based upon that, may have a very limited value. If, however, you're in the federal court system and you may face a jury and you might get punitive damages against you, that raises the settlement value of your case. That also forces the other parties to negotiate in good faith. So it gives you leverage that you did not have. So maybe this is the start of a leverage movement, different kind of leverage, but a leverage movement for shareholders. And it occurred in this particular Supreme Court. I'm not a fan of all the Supreme Court justices, but I'm a fan of that particular action. And the reason why I got to that point was Alpine is up in the federal courts. And I'm wondering, from position of FINRA, if perhaps Alpine might be a case that might go up, or at least somebody might attempt to take it up to the Supreme Court to again to challenge the power, but this time of FINRA, which is the irony of all ironies, is that we would love FINRA's powers to be limited, perhaps their immunity to be stricken, but we don't want the scumbags from Alpine to get let off. So we might have a conflict. Remember, we talked about a conflict potentially between maybe Rabari, Reichman, and GTII. Well, we might have a conflict here about the results between Alpine and FINRA, because maybe either one benefits us, therefore. So what else am I going to gab about? Let me take another quick look. Why are they diluting the company? If you're referring to GTII, I don't know who. So let me put it up. This is from Market Watcher. So why are they diluting the company? I don't know which company. If it was, why are the management diluting GTII? If that's the reason, if they can create, shares. I mean, I don't know why. I haven't spoken to them. They've not told me. But if you could generate wealth out of thin air, that would be a reason. And you wouldn't care about the dilution. You would be diluting yourself, of course, in more ways than one. You'd be diluting yourself. But, if you give yourself 60 million shares and your shares are worth, let's say you have 30 million shares and you give yourself 30 million shares, that's 100 million shares. But you dilute, it's 100% of your shares, but you dilute your shareholders by 10%. That makes sense. You're in a much better position, and you may not have paid for your shares, and there's still been dilution. So if that was the question, then hopefully that answered it. If I was too dumb to understand the question, which often is the case, then I don't know. Is there a timeline with Alpine and those other guys in court? Yeah, it's a timeline. Unfortunately, the timeline is when the court decides. It shouldn't be, it shouldn't be 6 months. I think the oral argument was March, and then there was some briefing post. This is referring to Alpine in DC. I think the oral argument was March. There was some minor briefing that occurred after that, I think in May or June. So we're about 6-7 months. So we should be done. There may be a case, the only reason why sometimes it doesn't get done is there may be another case that's pending, either in that same appellate circuit, or before the Supreme Court, or something else, and the court wants to see what happens. I do recall that in Alpine Circuit, there were 2 other cases involving FINRA and similar arguments, and they were ahead. I think one was Kim. I don't remember the other one. If I recall, they were slightly ahead of Alpine in order. So in other words, if there was an appeal or if there was a cert to the Supreme Court, they were moving ahead. So it might be the case that the court in Alpine is waiting to see what happens in those cases, or hasn't ruled on those cases. It doesn't necessarily have to be the same panel. So you might be in front of a circuit. They might have, I'm making up numbers, but let's say it's each of the 3-judge panel. Maybe there's 15 judges. So there might be 5 different groups of 3 judges. Those groups might change. So you could get conceivably, if something's not settled, you could get a different ruling from one than you get from another. That kind of that way. And you could have different circuits having different opinions. So if the U.S. is broken down into 10 or more circuits, the Ninth Circuit out here could be different than the Fifth Circuit. They could have a different ruling. And until the Supreme Court rules and kind of gets everything together, you could have different rulings in different jurisdictions throughout the country, and that often happens. And you could see from the Supreme Court this year, they don't really decide a whole boatload of cases. So it might take quite some time to get your case there. So I'm going to pull over and take a look at this next one. Does anyone know if we're restricted? Let me put it on the screen. Hopefully I can put it on the screen. Does anyone know if we will have our restricted reward dividend shares unrestricted? So it's a good question. That's what I'm supposed to say. That's what everybody says, by the way, even if it's a bad question. I don't know. And the reason I say that is because in the conditions hiring Rabari, so it said he's COO and he's going to be hired as CEO, and it listed 3 conditions. One of the conditions was to do something with regard to the dividend. Since July, I'm not aware of anything that happened with regard to the dividend. I don't know if they have, an expectation of doing something, but I'm not aware of any change. If anybody out there is aware of any change that happened since July, or any notice that went on, or anything like that, I'm happy to hear it. But I'm not aware of any action taken by GTII, and apparently that condition was satisfied, or else Mr. Rabari wouldn't have been made CEO, because that apparently was a condition of him being made a CEO, but I don't know what it was. And, I'd heard, the receiver will have, part of the receiver's duties, I don't know specifically what he'll do, but when I looked at the order, the first thing was to take corrective action, to make sure all the filings are compliant, et cetera. Yeah, so part of the action of the receiver, and I'm certainly going to communicate, whatever you guys communicate to me you think are the most important issues. But yeah, the most important job the receiver has is taking corrective action to correct whatever deficiencies exist, including, the filings, making sure all filings are done. We've talked about a few filings, a few 8Ks that haven't been done, to hopefully get it to a trading status so everybody can trade it, not like it is currently. And, pursue assets, pursue litigation that's necessary, take over control of the business, take over control of the bank accounts, all those kind of things. Yeah, all that stuff. So yes, the receiver can do all that once activated, as long as the court permits it. The court conceivably could look through the order and decide, I'm not going to give you this power. There might be 20 different powers. Maybe the court doesn't want to give all 20 powers. That wouldn't be a meaningful decision that a court didn't do that. The court might decide not to do that. So we don't know. But in answer to your question, as I look to my right, so that can be something the receiver can do. So thank you for the question. I'm looking, anything else that I see up here? Timeline, I gave you that. Dilution, I try to give you an answer. That's all I see. If anybody else has any other questions, put them in the chat. I'll take a quick look. If not, of course, once this is posted, I will look at the comments. And if you have specific questions and if I can answer them, I will do so. Sometimes I just can't, it's not like I don't look. It's just sometimes I can't. I'm trying to be pretty transparent about what's going on. But even me, I have to keep things quiet at times because it would be disadvantageous for us all if I wasn't. So sometimes if I sound cryptic, it's for a reason. I'm not trying to be not cryptic, and I will always come back to it. That's why I gave you the monkey order issue about reconsideration. I have to remind myself about that. It's a reconsideration. Monkey order about reconsideration. But that's like one thing I'm not telling you now, but that's something I'd like to tell you about. It's not like it's going to change your life and it's not meaningful, but it's an interesting, it's a procedural issue. And after I tell you, you'll understand why I didn't tell you. But it won't ultimately change the grand scheme of things, in my opinion. But it's an interesting issue, and I'll keep it to myself. So anyway, I have to keep some of that stuff to myself. Otherwise, especially as I file things, I try to tell you what I filed, and besides, hopefully, we get a positive result. Hopefully, it'll be meaningful to you. You'll get some information. Maybe it'll make things less complicated. Maybe it'll, whatever. Maybe you'll go to law school. I hope not. Maybe it'll go to medical school. Maybe actually that's good. Maybe it'll force you to go to medical school. Anyway, I will let you all go. I appreciate you all hanging out today. Feel free again to any comments, questions you have in the future. Feel free to reach out. When you have, and if you have particular issues you want a receiver to be aware of, I think I'm aware of, the dividend and those kind of things. But if there's things you want to be aware of, please let me know, or let the receiver know directly. When the receiver is appointed, I will let you know, and you can contact the receiver directly to express whatever you want. But other than that, I've gabbed enough. Be well, take care, have a great weekend. I'm going to be doing a live stream with JR Monday at 7:30 Eastern. So hope to see some of you there. And we'll talk later. Have a great weekend, everybody. Be well.